Stop scrolling. Seriously. If you receive Social Security benefits, or if someone in your family does, you need to hear this right now. Because the Supreme Court of the United States just issued a final verdict on a Social Security case that is directly affecting millions of Americans' monthly payments. And most people have absolutely no idea it even happened. They'll find out when they check their account and something looks different. I don't want that to be you. So stay with me for a few minutes because I'm going to break all of this down in plain, simple English. No legal jargon, no confusing government language, just exactly what happened, what it means for your money, and what 3 words you need to know before we're done. Let's start at the very beginning, because context matters here, and I want you to actually understand this, not just hear a headline. The Social Security Administration, which most people call the SSA, has been managing retirement benefits, disability benefits, and survivor benefits for decades. It's a system that tens of millions of Americans depend on every single month. For many people, especially retirees and disabled individuals, this isn't extra income. This is the income. This is rent. This is groceries. This is prescription medication. So when the Supreme Court gets involved in how Social Security rules are interpreted and applied, the stakes couldn't be higher. Now, here's what a lot of people don't realize. The Supreme Court doesn't just handle criminal cases or big political battles. The court also rules on administrative law cases, which are cases about how government agencies like the SSA are allowed to make decisions that affect ordinary people's lives. And that's exactly what happened here. A case made its way all the way to the top of the American legal system, and the court's final verdict has created a shift, a real, meaningful shift, in how your Social Security benefits are protected. So let me walk you through it step by step. Let's take a step back for just a second and talk about something called agency deference. I know that sounds complicated, but I promise it's not. For many years, there was a legal principle in the United States that basically said when a law passed by Congress is a little bit unclear or ambiguous, the government agency in charge of enforcing that law, whether it's the SSA, the IRS, or any other agency, gets to decide what that law means. And courts were supposed to defer to that agency's interpretation, even if a regular person or a judge might read the law differently. What this meant in practice for Social Security is this. If there was ever a gray area in the rules, a question about whether you qualified for benefits, whether an overpayment should be waived, whether a disability classification applied to your situation, the SSA essentially had the final say. Courts would step back and say, well, the agency is the expert here, so we'll go with their reading. And for a lot of people, that system worked fine. But for a lot of other people, it didn't. Because sometimes the SSA's interpretation of those gray areas was not in the beneficiary's favor. Sometimes it led to people losing benefits they deserved. Sometimes it led to overpayment decisions that devastated families. And when those people tried to fight back in court, they kept running into this wall. This deference doctrine that protected the agency's decisions even when those decisions seemed wrong. Here's what a lot of people don't realize. The Supreme Court, in a landmark ruling, overturned that old deference doctrine. The case is now commonly referred to in connection with what legal experts are calling the most significant shift in administrative law in decades. The court said, in essence, that agencies like the SSA no longer get automatic deference when they interpret ambiguous rules. Instead, courts, independent federal judges, now have the power and the responsibility to look at those rules themselves and decide what they actually mean. The agency's interpretation is still considered, but it's no longer the end of the conversation. Now, why does this matter for you? Stay with me, because this is where it gets very real and very personal. This ruling changes the power dynamic between the SSA and the people it serves. Right now, in 2026, what that means is that if the Social Security Administration makes a decision that you believe is wrong, if they say you owe them money back, if they deny a benefit claim, if they reduce your payment based on their interpretation of the rules, you now have a much stronger foundation to challenge that decision in court. Because the court is no longer automatically going to side with the agency just because the agency said so. The judge is going to look at the law independently. And that is a genuinely big deal for millions of Americans. Let me give you a real-life example so this clicks. Imagine a woman, let's call her Margaret, who is 68 years old and has been receiving Social Security retirement benefits for 3 years. One day she gets a letter in the mail from the SSA saying she was overpaid by nearly $9,000 over the past 2 years, and she needs to pay it back. Margaret is shocked. She did everything right. She reported her income when she was supposed to. She filled out every form they sent her. But the SSA had interpreted a rule about how her part-time work affected her benefit amount in a way that Margaret, and frankly, a lot of people, didn't agree with. Under the old system, Margaret's chances of successfully challenging this in court were pretty slim, because the court would likely say, "We defer to the SSA's reading of the rule." Under the new landscape created by the Supreme Court's verdict, Margaret's challenge carries real legal weight. An independent judge can now look at that rule and decide whether the SSA's interpretation was actually correct, or whether Margaret was right all along. This part is important, so I want to be really clear about something. This ruling does not mean that the SSA is suddenly going to stop making decisions you disagree with. It does not mean you automatically win if you appeal. What it means is that the playing field is more level than it has ever been before. It means the law now requires courts to genuinely evaluate the rules, not just rubber stamp what the government says. And that matters enormously for disability claimants, for survivors, for people facing overpayment demands, and for anyone who has ever felt like they had no real recourse when the SSA got something wrong. Now, let's talk about the 3 words. Because I told you at the beginning that 3 words could save your benefits, and I meant that. Those 3 words are, request a hearing. That's it. Request a hearing. These 3 words activate your legal right to have your Social Security case reviewed. They are the words that get you in front of an administrative law judge. And now, thanks to this Supreme Court verdict, potentially in front of a federal court that will evaluate your situation without automatically siding with the agency. A lot of people who receive an unfavorable decision from the SSA, whether it's a denial, an overpayment notice, or a benefit reduction, simply accept it. They don't know they can fight it. They don't know the process. They're overwhelmed, and they give up. And billions of dollars in legitimate benefits go unclaimed or improperly recovered every year because of that. Let's take a step back and walk through what the appeals process actually looks like, because understanding it is how you protect yourself. If the SSA makes a decision you disagree with, you typically have 60 days from the date on the notice, plus a few extra days for mail, to file an appeal. The first level is called reconsideration, where a different SSA employee reviews your case. If that doesn't go your way, the next level is a hearing before an administrative law judge. And this is where the request a hearing step becomes so critical. After that, there's a National Appeals Council, and beyond that, federal court, where the Supreme Court's new ruling now gives you a stronger position than ever before. The key is that you have to take action. The system does not fix itself automatically. You have to request that hearing. You have to start that process. And here's something a lot of people don't realize about the overpayment issue specifically, because it's one of the biggest sources of confusion and financial pain for Social Security recipients right now in 2026. The SSA has significantly ramped up its overpayment recovery efforts over the past couple of years. People are receiving letters out of the blue demanding thousands of dollars back. And many of those people are elderly, on fixed incomes, or already struggling. What you need to know is that you have the right to request a waiver of that overpayment if you can show that the overpayment was not your fault and that paying it back would cause you financial hardship. That's a legal right. But again, you have to request it. You have to take those 3 words, request a hearing, and also request that waiver. Don't just pay the amount if you believe it's wrong or if repayment would devastate you financially. Now, I want to take a moment and talk about scams, because anytime there's a major news story or legal ruling involving Social Security, the scammers come out in force. And I mean that literally. Within days of major SSA announcements or court rulings, fraudsters start calling seniors pretending to be from the Social Security Administration, telling them that their benefits are suspended because of the court ruling, or that they need to confirm their Social Security number to protect their account from the legal changes. I need you to hear this clearly. The real SSA will never call you and threaten to suspend your benefits. The real SSA will never ask for your Social Security number over the phone. They already have it. The real SSA will never ask you to pay anything by gift card, wire transfer, or cryptocurrency. If you get a call like that, hang up. Then call the official SSA number yourself, 1-800-772-1213, and report what happened. Please share this warning with older family members because they are the primary target of these scams and they deserve to be protected. Let's talk about what this all means going forward into the rest of 2026 and beyond, because the implications of this Supreme Court verdict are still unfolding. Legal experts are watching very carefully to see how federal courts begin applying this new standard to Social Security cases. Advocacy organizations that work on behalf of disability claimants and seniors are preparing test cases specifically designed to use this new legal landscape to expand protections for beneficiaries. And the SSA itself is in the process, right now, of figuring out how it needs to adjust its own decision-making processes to account for the fact that its interpretations of the rules are no longer automatically going to be upheld in court. What that means for you as a beneficiary is this: stay informed because things are actively changing. The decisions that courts make over the next 12 to 24 months are going to shape the practical impact of this ruling for years to come. If you have an ongoing appeal, or if you're considering starting one, this is genuinely one of the better moments in recent history to pursue it, because the legal environment is more favorable to claimants than it has been in decades. That's not me being dramatic. That's the honest reality of what the Supreme Court's final verdict created. Here's what I want you to do after you finish watching this. First, check your mail and your My Social Security account online. If you've received any notices from the SSA that you haven't fully read or responded to, read them today. Don't let a deadline pass. Second, if you have received a decision you disagree with or an overpayment notice you believe is wrong, write down those 3 words on a piece of paper right now. Request a hearing. Then go to SSA.gov or call 1-800-772-1213 and ask how to begin that process. Third, if you're helping an elderly parent or a family member navigate their benefits, sit down with them and make sure they understand that they have rights, they have legal standing to appeal, and that the legal environment right now supports them more than it has in a very long time. And fourth, consider consulting with a Social Security attorney or an accredited claims representative if your situation is complex. Many of them work on contingency, meaning they don't get paid unless you win. You have nothing to lose by making that call. The bottom line is this: the Supreme Court's final verdict is not just a legal technicality buried in a law journal somewhere. It is a real, practical change in the relationship between the Social Security Administration and the millions of Americans who depend on its programs. It gives you more power. It gives courts more independence, and it means that when the system gets something wrong, and sometimes it does get things wrong, you now have a better chance of getting it corrected than you've ever had before. But only if you know your rights. Only if you take action. Only if you remember those 3 words. Don't leave money on the table. Don't accept a decision that might be wrong just because the letter sounds official and the system feels too big to fight. You have rights, and those rights just got stronger. Check your My Social Security account today. If something looks off, request that hearing. Share this video with a family member, a neighbor, anyone you know who gets Social Security, because the person sitting next to them at bingo or church might be losing benefits right now without even knowing they can fight back. Stay informed, stay protected, and I'll see you in the next one.